Some folks collect stamps or coins. Me, I've spent 25 years perfecting my backyard oasis, only to have my HOA decide they wanted it for themselves. What they didn't count on was a retired engineer with nothing but time and a whole lot of stubbornness. If you've ever dealt with an HOA nightmare, make sure to hit that subscribe button and give this video a like. Share your own HOA horror stories in the comments. I read every single one, and believe me, after what I went through, I appreciate knowing I'm not alone. Back in '98, when Mary and I bought our place in Lakeview Estates, we thought we'd found paradise. The neighborhood was established exactly 11 years earlier, with each property backing to what the sales brochure called shared green space that led down to our private lake. What they didn't emphasize was that this shared space was actually just the back portion of everyone's property, with an informal understanding that we all maintained it but could use it. For 25 years, I nurtured that land. I planted azaleas that now stand 6 feet tall. I put in a stone patio where Mary and I drank our morning coffee until she passed 5 years ago. I even installed a small koi pond that my grandkids love. This wasn't just land, it was memories. Then came the new HOA President, Karen Richardson. She moved in 3 years ago and immediately decided our peaceful community needed upgrading. At first, it was small stuff. Fines for trash cans left out an hour too long, nasty letters about mailbox colors. But last March, she crossed a line. I was working in my garden when I heard the sharp rap on my door. There stood Karen, clipboard in hand, wearing her trademark pantsuit like she was about to close a business deal. "Mr. Henderson," she said without preamble, "the HOA has voted to reclaim the community green space behind your property for development." I blinked. "What are you talking about? That's my yard." "Not according to our interpretation of the original bylaws," she said, handing me a notice. "This area has always been designated as community property. We're installing a walking path and community garden area." I looked at the paper in disbelief. They were claiming 15 feet of my backyard. The part with my patio, my azaleas, and Mary's memorial garden. "This is ridiculous," I said, my voice tight. "I've maintained this land for 25 years. I paid taxes on it. It's mine." "Your interpretation is noted," Karen said coolly. "You have 30 days to remove your personal property. After that, the HOA will have it removed at your expense. Additionally, you'll be assessed a fine of $100 per day until the area is cleared." She turned and walked away before I could respond, leaving me standing there with that ridiculous notice in my hand. That night I couldn't sleep. I dug out my original closing documents from the fire safe in my closet. There was my property survey, clearly showing my lot lines extending to the tree line at the back of my property, exactly where I'd always believed them to be. The next morning, I called my neighbor Bill, who'd lived in Lakeview Estates since it opened. "Bill, did you get one of these notices about the green space?" He sighed heavily over the phone. "Sure did, Jim. They're taking 12 feet from my backyard, too. Said they're putting in some kind of meditation garden." "This is insane." I said, "Did you check your original survey?" "Yep," Bill replied. "Shows the same as yours. Our property goes back to the trees. But Karen says the original developer had some kind of verbal agreement that it would be community space." "A verbal agreement? That's not legally binding." "Tell that to the HOA board," Bill said. "They've already fined me $500 for resisting community improvement." Over the next week, I discovered that Karen and her new board majority had sent similar notices to 17 homeowners, all of us backing to the green space. Each of us was being fined daily for non-compliance. I decided to attend the next HOA meeting, which turned out to be standing room only with angry homeowners. Karen stood at the front, looking smug. The board has approved this beautification project to enhance our community's value and appeal. The walking path and community gardens will be a lovely addition. "What about our property rights?" shouted a woman from the back. "The original development plan clearly intended this area for community use," Karen replied smoothly. "We're simply finally realizing that vision." I stood up, survey papers in hand. "Mrs. Richardson, my property survey clearly shows my lot extending to the tree line. I've paid taxes on this land for 25 years. You have no legal right to it." Karen's smile tightened. "Mr. Henderson, we've had our attorney review the situation. He's confirmed that the HOA has the authority to reclaim community space under our bylaws. If you continue to resist, we'll be forced to take legal action." The meeting deteriorated from there, with homeowners shouting and Karen threatening additional fines. As I left, I felt a hand on my shoulder. It was Bill. "Listen, Jim," he said quietly. "I know a guy, real estate attorney, retired like us. He hates HOAs with a passion. Want me to set up a meeting?" "Absolutely," I said. "This isn't right." 2 days later, I met with Tom Reynolds, the attorney Bill recommended. Tom was in his 70s, sharp as a tack, with a no-nonsense demeanor that reminded me of myself. "Let me see your documents," Tom said, spreading my survey and closing papers across his desk. He examined them carefully, then pulled out a magnifying glass to look at the surveyor's stamp. "Interesting," he murmured. "Very interesting indeed." "What is it?" I asked. "This survey was done by Harrison and Associates, right?" "Yes, that's what it says." Tom smiled. "I know George Harrison, retired now, but he was the most meticulous surveyor in the county. If he says your property line is at the tree line, then that's exactly where it is. So what can we do?" Tom leaned back in his chair. "First, we send them a formal letter challenging their claim. We request they produce any documentation proving this land is community property. My guess is they don't have any, and if they don't back down, then we sue them," Tom said simply. "Not just you, all affected homeowners. A class action. This kind of bullying is exactly why HOA laws were strengthened in our state 5 years ago." Over the next few weeks, Tom drafted a cease and desist letter to the HOA. Meanwhile, Karen and her board escalated their tactics. The daily fines increased to $200. They sent workers to mark trees for removal along my property line. They even had the audacity to schedule a groundbreaking ceremony for their new community space. You wouldn't believe what they did next. One morning, I woke up to find stakes and pink tape running through my garden, right through Mary's memorial. Roses, that was it. I called Tom immediately. "They've crossed a line," I told him. "It's time to fight back." "We're ready," Tom said. "I've already spoken with 12 other homeowners. We're filing suit tomorrow. The lawsuit was filed on a Monday. By Wednesday, Karen had called an emergency HOA meeting. To my surprise, Karen began the meeting with a conciliatory tone. "In light of recent concerns," she announced, "the board has decided to revise our plans. We'll only be taking 8 feet from each property, not 15, and we'll personally reimburse everyone for all fines paid to date." Murmurs went through the crowd. Some homeowners seemed relieved. "I don't trust her," Bill whispered to me. I shook my head. Neither do I. After the meeting, Karen approached me directly. "Mr. Henderson, I hope we can put this behind us. We're willing to make a special accommodation for you, given your circumstances." "What circumstances are those?" I asked coldly. "Well, you know, living alone since your wife passed. We thought you might appreciate the community space more than others." I saw red. "Are you using my wife's death to manipulate me, Mrs. Richardson?" "Of course not," she said, though she wouldn't meet my eyes. "I merely meant—" "You meant nothing," I cut in. "This lawsuit is moving forward. We'll see you in court." Karen's pleasant mask slipped. "You'll regret this, Henderson. The HOA has deep pockets and a very good attorney." "So do we," I replied, walking away. If this HOA sounds unbelievable already, make sure to hit subscribe. You don't want to miss how this ends. 2 weeks later, we received the HOA's official response to our lawsuit. They were countersuing for harassment and legal fees, claiming our lawsuit was frivolous and had caused them emotional distress. "They're really doubling down," Tom said when we met to review their response. "This is good. It shows they're scared." "How is that good?" I asked. "Because they're overplaying their hand. Their attorney should have advised them to settle. Instead, they're digging in deeper. It'll make our case stronger." As the court date approached, tensions in the neighborhood escalated. Karen's supporters began harassing those of us in the lawsuit. My tires were slashed. Bill found dog feces on his porch. Someone even spray-painted HOA hater on my garage door. We reported everything to the police, but without clear evidence of who was responsible, there was little they could do. Finally, the court date arrived. Tom had gathered all 17 plaintiffs in the hallway outside the courtroom. We were nervous but determined. Karen arrived with her board members and their attorney, a slick-looking young man in an expensive suit. They looked confident, almost smug. The judge called our case. As we entered the courtroom, I noticed Tom carrying a large flat document tube. "What's that?" I whispered. "Exhibit A," he said with a wink. The HOA's attorney presented their case first, arguing that the original developer had intended the green space to be community property, and that the HOA had the right to reclaim it for the good of the community. Then it was Tom's turn. He began by establishing that every plaintiff had a property survey clearly showing their lot lines extending to the tree line. "But," the HOA attorney objected, "those surveys are outdated. The HOA had a new survey done last year that clearly shows the community boundary." Tom smiled. "I'd love to see that new survey." The HOA attorney handed it over. Tom examined it briefly, then called his first witness, George Harrison, the original surveyor, now in his 80s, but sharp as ever. "Mr. Harrison," Tom began, "did you perform the original survey for Lakeview Estates?" "I did," Harrison replied, "every single lot." "And where did you place the rear property lines?" "At the tree line, just as shown on these surveys," Harrison said. "The developer never mentioned any community green space. That land was always part of each homeowner's property." The HOA attorney jumped up. "Objection! Hearsay!" "Sustained," said the judge. Tom nodded. "Let me approach the bench, Your Honor." Tom unrolled the document from his tube, the original signed development plan for Lakeview Estates, complete with the surveyor's stamp and the developer's signature. "As you can see," Tom said, "there is no designation of community green space. Each property extends to the tree line exactly as shown on the individual surveys." The judge examined the document carefully. "Where did you obtain this, Mr. Reynolds?" "From the county archives," Tom replied, "where it's been since 1987. The HOA's new survey appears to be completely fabricated." The HOA attorney paled. "That's impossible. Our survey was done by a licensed professional." Tom called his second witness, a surveyor who examined the HOA's new survey. "In my professional opinion," he testified, "this document is a forgery. The surveyor's license number belongs to a man who died in 2005. The methodology used doesn't meet current standards, and several measurements are mathematically impossible." The courtroom was silent. Karen and her board members shifted uncomfortably in their seats. Tom wasn't finished. He presented evidence that Karen had paid for the fake survey out of HOA funds without board approval. He showed emails between Karen and a landscaping company where she promised them the land in exchange for a kickback. He even produced a recording, secretly made by a disgruntled board member, of Karen admitting she knew the land belonged to homeowners but was confident they wouldn't fight back. By the time Tom finished, the HOA's attorney was frantically whispering with his clients. The judge looked furious. "Given the evidence presented," the judge said, "I have no choice but to rule in favor of the plaintiffs. The HOA's claim to this land is baseless and fraudulent. Furthermore, I'm referring this matter to the district attorney for possible criminal charges against Karen Richardson and the HOA board members who participated in this scheme." The courtroom erupted in cheers. Karen and her board looked like they'd seen ghosts, but the best part came a week later, when the new HOA board, elected by homeowners after Karen's resignation, voted to disband the HOA entirely, returning all collected fines and establishing a simple neighborhood association with limited powers. As for my backyard, it's more beautiful than ever. The azaleas Mary planted are thriving, and my grandkids love feeding the koi. Last weekend, all the neighbors who were part of the lawsuit came over for a barbecue. We set up tables right where Karen had wanted, to put her walking path. Looking back, I realized something important. Bullies only win when good people stay silent. HOAs were meant to protect property values, not steal property. If you're facing something similar, don't back down. Do your research, know your rights, and stand your ground. Because sometimes the backyard you save isn't just land, it's memories, dignity, and the knowledge that justice, though sometimes slow, eventually prevails. If you found this story satisfying, make sure to hit that subscribe button for more tales of everyday people standing up to injustice. And if you've ever faced an HOA battle, share your story in the comments below. Together, we might just help someone else find the courage to fight back.